Thank you everyone for joining us today at today's webinar. My name is Samira Mari and I'm the head of business development and marketing at Afridi and Angel. Speakers today are partners Bashir Ahmed and Abdus. Before I hand over to Bashir and Samad, I want to remind you to submit your questions in Q&A throughout the webinar. We will address questions during the presentation as well as at the end. The webinar is 45 minutes long, and we will try to address all questions and have any discussion during the 45 minutes. The webinar is recorded. A recording will be posted on our website next week and shared with all of you, plus the slides. Thank you again for joining us, and over to you, Bashir.
Thank you very much, Samra. Welcome, everybody. We're here to discuss today changes in the UAE Commercial Companies Law. As most of you, if you've been here more than a couple of years, would have noticed, there has been a deluge of new legislation being enacted in the UAE in the last couple of years. We've seen reforms right across the board, all numbers of subjects and so on. And the fact that a number of the federal laws are being published as federal decree laws is significant. This indicates that they're not going through the usual consultation process, which involves all 7 emirates, and are being, if I can say, hurriedly pushed through as decree laws. The Companies Law of number 32 of 2021 is no exception, again, was pushed through as a decree law. However, I should add that the reforms to the Companies Law were in place quite a while before this. Firstly, the Companies Law, the original Companies Law came out in the late 80s and was largely static. There wasn't much happening in the Companies Law space until 2015, when the Companies Law was revamped and the old law was repealed and a new law, number 2 of 2015, was enacted. Almost as soon as it was, we saw a spate of further amendments, developments in the law, which indicated that the environment was becoming much more dynamic. And this has now culminated in the 2021 Companies Law, which came into force last year in January 2022. The law, I would say, hasn't really changed much for those of us who are dealing with LLCs and so on, but is significant in the public sector. That's where we've seen the most changes, and that's what Samad is going to talk about. So the driving force behind the 2021 law, as opposed to earlier amendments, has really been, I would say, regulatory introductions of new concepts into the legal space, such as SPACs, introducing concepts such as spin-offs, demergers, etc. So I will hand over to Samad, who will run through these for you.
Thank you, Bashir. Now, as Bashir has said, there have been subtle but important improvements and adjustments to the company's law regime here in the UAE. Before I get into the specific changes and sort of the issues to note, I'd like to just dwell on what we see as a theme, if I may, for 2023. Now, what we as a law firm have seen is a trend towards a focus on enhanced compliance. Traditionally, in particular, private sort of limited liability companies established onshore have seen a light touch regime insofar as corporate governance and corporate compliance requirements are concerned. We feel that the time that has changed, and that will continue to change. And there will be, going forward, an enhanced focus on making sure that even private companies incorporated onshore here in the UAE comply with the letter and the requirements of the law insofar as filings are concerned, or insofar as corporate governance requirements are concerned. And I think that will be the theme for 2023. Now, Federal Decree Law 32 of 2021 introduced a number of changes, and we'll focus on some of the specific changes later on. But just as a highlight, as Bashir mentioned, the law introduced certain new corporate vehicles that we had not seen in the past. The intention behind this is to modernize the corporate law regime in the UAE to allow for sophisticated transactions and transaction structures that are perhaps well known elsewhere to become familiar to the UAE market, and to allow for flexibility for investors to structure corporate transactions in the way that they're accustomed to elsewhere. We also saw, to much fanfare, the introduction of the concept of a special purpose acquisition company, or a SPAC, or a blank check company, as it's known in certain parts of the world. And we'll discuss some of the developments on that front later. Insofar as private limited liability companies are concerned, notice requirements for general meetings have once again been updated and modernized, as well as the method of notifying shareholders of general meetings have again, the permitted methods have been made more flexible and have been modernized. In addition, some of the thresholds for shareholder initiated actions, such as a shareholder of a limited liability company calling a general meeting, those thresholds have been reduced. So again, we see a flexibility certain degree of flexibility being introduced, and the law being modernized to reflect best practices in the market. Coming back to the introduction of new types of vehicles, we have two concepts of note. The first being the so-called special purpose vehicle, which the law simply describes as a company that is incorporated for the purposes of ring fencing assets and liabilities. Now, as a concept, this is not new to most corporate advisors, but we have not yet seen this concept being applied and tested in legal practice or in structuring. Now, there's a question there as to how a so-called special purpose company is different from a single shareholder company incorporated for the purposes of simply holding assets. A limited liability company under law allows for limited liability and protection for the shareholder in most instances. So it remains unclear to us what particular purpose this vehicle was intended for, but perhaps we'll see more clarity in the coming months and years. The special purpose acquisition company, or SPAC, again, there was much media speculation on when this was introduced. ESCA, the Securities and Commodities Authority, which is in charge of oversight of listed companies, was very quick to issue Decision 1 of 2022, which set out the ESCA requirements for a special purpose acquisition company to be listed on one of the UAE public markets. The first UAE SPAC has been incorporated and is listed on the ADX, being the exchange, the public market in Abu Dhabi. It's ADC Acquisition Corp, but as far as I'm aware, they've not yet actually completed a transaction. So it remains to be seen how that particular concept will flow through to the logical end result of having a SPAC merge with another company. As Bashir mentioned, there have also been a number of changes to the regime for public joint stock companies. Again, the focus has been to allow flexibility in the structuring of corporate transactions. So there's now some legislation allowing for spin-offs, demergers, for public companies to be split up, and that should, depending on how these rules are implemented and enforced in practice, allow greater flexibility in corporate transactions. Again, just going through the list, issuance of PJSC shares at a discount subject to ESCA approval has been allowed. There's further rules on the issuance, on the value, the par value of shares of the public joint stock companies. Again, we see a trend towards flexibility. insofar as limited liability companies are concerned, as mentioned earlier, we've seen a move back to the requirement for notices for general meetings of LLCs to be for 21 days rather than the previously introduced standard of 15 days.
Whereas the previous one was 21 before that.
Correct. So it's been changed back to what was the original standard before the 2015 law was introduced. Notably, and this will be of interest to many, the statutory reserve contributions have actually been reduced, so that previously it was the case that a minimum of 10% of annual profits had to be set aside for the statutory reserve up to the point at which the company has a reserve equal to 50% of its issued share capital. That contribution requirement has now been reduced to 5%, potentially freeing up some cash in certain companies for reinvestment. Additional flexibility, as I mentioned earlier, has been introduced on the methods for convening general meetings. Now, the law specifically says that so-called modern technological means can be used to issue notices to shareholders. Now, I'll pause at this issue to just analyze that a bit further. What does that mean? And can companies that do not have memoranda of association that contemplate this flexibility rely merely on this provision of law? So let's examine this a bit further. Let's assume that there is a limited liability company established in Dubai, which does not have within its MOA flexibility to issue general meeting notices by email, for example. Our view is that such companies should probably take a conservative approach and follow the letter of their memorandum of association. And if they want to, in addition to the specific requirements of their memorandum of association, issue additional notifications through, for example, electronic means, then of course they may do so, but they should make sure that they're satisfying the requirements of their constitution until such time as that constitution, being their memorandum of association, is updated to incorporate this flexibility that the law provides. So I've just seen some questions that have come through, and these are very good questions, which I'll pause here to answer. The first question is whether an AGM can be conducted virtually. Now, the law actually does clarify this, and it says that general meetings for LLCs specifically can in fact be conducted through technological means, which we read to mean virtually. However, again, our view is that if the memorandum of association of the company doesn't have flexibility to hold these meetings in a certain way, then the conservative approach and the prudent approach is to hold those meetings in the manner prescribed by the memorandum of association until such time as that constitution is updated to incorporate this flexibility and the modernization in the law. We do not consider that it would be prudent to hold a general meeting in a way not contemplated in the memorandum of association. Now, the next question that we've received is whether a limited liability company can adopt or implement a employee share option scheme. Now, this is I don't think this is the correct forum for fully exploring this topic, but the answer is, in theory, yes. However, the way that a limited liability company operates in practice and the way that shares or interests in a limited liability company are transferred, registered with the notary public and then the economic department in the relevant emirate, I typically don't consider that an LLC onshore in the UAE is an appropriate vehicle through which to adopt employee incentive schemes such as an ESOP.
I would never recommend it. It would be a bureaucratic nightmare, and one would be stuck with all sorts of issues as to what to do when the employee leaves. You cannot force a transfer back of the shares. what do you do with heirs, etc. So I think it would be a complete disaster for an LLC to be issuing ESOPs.
Agreed, Bashir. So just one other change that I'd like to quickly mention, which is not identified on these slides, and that is that in the 2015 law provided that a manager of an LLC has to convene a general assembly where shareholders holding at least 25% of the capital of the company request for a general meeting to be convened. That standard has actually been reduced from 25% to 10% of the capital of the company. Quite a drastic and important change, and one that is very relevant to those LLCs that have multiple shareholders that are not necessarily related parties or connected parties. So it in fact is an enhancement to the rights of, for example, a minority investor. Now, one or more shareholders holding 10% rather than the earlier standard of 25% can compel the general manager of an LLC to call a general meeting. So an important change. Now, this is again an issue that has come up in the work that we've done over the last year as a law firm. One of the long-standing issues of confusion is this provision in the company's law, which has been there for the past few iterations, that the provisions applicable in the law, stated in the law for public joint stock companies also apply to limited liability companies. And this cross-referencing has caused much headache and confusion for advisors across the board. Now, shortly after the 2015 law was issued, there was actually a cabinet decision that clarified or rather ministerial decision that clarified which provisions of PJSCs did and did not apply to limited liability companies. And this was quite a welcome clarification for lawyers and for advisors. However, since that 2015 law has been repealed and replaced, we've not seen a further iteration of the 2016 ministerial decision that updates those references and those concepts. So while the new law, being the 2021 iteration, preserves decisions and implementing regulations issued under the old law, it also provides that where there's inconsistency, the new federal law prevails in each instance. So the question remains, there may be one or more provisions of the PJSC section of the new companies law that could possibly be construed as being applicable to limited liability companies. And it's not yet clear, or rather we do not have the desired level of certainty to advise with confidence and clarity as to which provisions apply and which provisions don't apply, because we don't have the comfort of an updated decision or implementing regulation on this issue. One of the issues that we've considered and which we frequently consider is the financial assistance prohibition and whether or not it currently applies to limited liability companies. Again, this was an issue that had been clarified under the 2015 regime, but at present, we do not feel that the requisite clarity is there on an issue of this level of importance. In terms of action items, as I mentioned earlier, there's been a cabinet decision that sets out administrative penalties, again, a focus on compliance with the letter of the law. So all companies were required to regularize and update their status to make sure that their constitution complies with Federal Law 32 of 2021. The deadline for compliance has now passed. It was January 2023, and fines are in theory applicable pursuant to Cabinet Decision 78 of 2022. So whether or not a company has in fact regularized its position, it should look to do so now in order to make sure that its constitution is in line with the most recent iteration of the law. Quite importantly, as I've mentioned, there have been changes to the arrangements for convening and holding a general meeting. So in line with some of the good questions we've received, the constitution of the company should preferably be updated to allow and to incorporate the flexibility that the law now allows. And so that companies can benefit from modern means of satisfying corporate governance requirements. And item number 3 on the current slide that you see goes back to what I consider as a theme for me for 2023, which is compliance. Historically, and this is a particular issue we see when diligencing limited liability companies onshore in the UAE, often basic corporate governance requirements are overlooked because historically they've not been the subject of sanctions or penalties. I expect that in the near future, there's a chance that that will change. And matters like ensuring that annual general meetings, even for private companies, are held in the manner contemplated in the law and the company's constitution. This will become important. Ensuring that accounts are prepared by the manager, are put to an audit by an external auditor licensed in the UAE, and then laid before a general meeting for approval. Following that process, which again has always been there in the law, but commonly has been ignored. And accordingly, we suggest that companies start looking at what are fairly basic requirements and making sure that they do in fact comply with these matters. Also, of course, it would be remiss to also mention that we are looking at corporate taxation being introduced in the coming months. So it's a good idea for all businesses to look at making sure that their accounting and their audit is properly completed this year in order to make sure they are correctly prepared for the introduction of tax in the UAE, corporate tax in the UAE next year. And now I will leave the floor once again for Q&A.
Yes, there were a couple of questions. Actually, there are some questions, but one of the questions that came through. What are the special requirements that apply to company name for a single shareholder LLC?
Okay. This is one of the silliest provisions of the company's law, in my view, and I just find it ridiculous. So I'm going to let Ahmed answer that one. Okay.
So historically, for those that may not be aware, historically it was the case that a limited liability company had to have at least 2 partners. That position was changed in the 2015 law that allowed for single shareholder companies to be incorporated. The drawback was that the law introduced a somewhat bizarre naming convention, which is now that a single shareholder company must have its name, and then after the letters LLC or the words limited liability company must have single owner or sole proprietorship or something similar that denotes that it only has one partner within its trade name and its legal name. Now, as Bashir says, this is a somewhat unusual requirement, not unheard of in some jurisdictions, but somewhat inconvenient, in particular where you have a company that historically had more than one partner and is now converting to a single shareholder company, and which may then need to adopt a completely different naming convention and have to update its various registrations, its bank accounts, its invoicing arrangements, simply to reflect the fact that it is now a single shareholder company. So a somewhat inconvenient requirement of the law, but yes, that in a nutshell is what the convention is for single shareholder companies.
Thank you, Samad. Another question that came in earlier. Have you seen administrative penalties being applied for non-compliance with the new law?
We have not as yet, bearing in mind that these wouldn't necessarily be the subject matter of public, so they wouldn't be public record because they would be imposed on companies privately. However, the deadline has only just passed, so it remains to be seen how strict or vigilant the relevant emirate level regulators will be on ensuring compliance. But again, my expectation is that there will be an enhanced requirement for companies to ensure compliance, and there will be the advent of monetary sanction for those that are continuously non-compliant.
Yeah, I would say it is too early, but we have seen in other sectors such as ESR notifications, labor requirements, etc. The authorities are becoming much more aggressive in imposing fines and really not wasting much time in doing that. They're very quick at sending out notices. And I think it's only a matter of time before we see that with the companies law.
Okay.
So I've also, Samir, I've just received a question on whether the new law has affected UAE branch offices of foreign companies and whether there have been changes in terms of governance. So the UAE Companies Law does not directly deal with governance matters insofar as branch offices are concerned. I mean, remember that a branch office in the UAE is not a distinct legal entity. It is an extension of the foreign parent. So insofar as corporate governance is concerned, a branch office doesn't have its own direct board of directors, for example. It'll typically have a single manager. However, bear in mind that the law also states that in theory, and this is observed, is not observed rather, as far as I'm aware, a branch office of a foreign company is required to prepare and file accounts with the Ministry of Economy with which it's meant to be registered. Now, again, as far as I'm aware, this is not a requirement that most branch offices of foreign companies observe in the UAE. It remains to be seen, again, with the new focus on annual filings and compliance, whether this requirement to prepare and file accounts will also be more actively enforced. And don't forget, this links into, as Bashir mentioned, issues like economic substance, and with, again, the advent of corporate taxation, which also requires compliance with economic substance requirements and with respect to compliance with transfer pricing rules. I suspect that branch offices of foreign companies may also find that they have an additional or heightened compliance burden to deal with in the UAE, whereas historically it's been light touch.
Okay, there are a few more questions, Samad, that came through. What has the new law impacted civil companies established in the UAE, in Dubai?
So the so-called civil companies are actually a bit of an anomaly insofar as the word denotes. They're not incorporated pursuant to or established pursuant to the company's law. They are, by definition, established pursuant to the certain enabling provisions in the UAE Civil Code. So those companies are, by definition, not within the purview of the company's law because they are not companies as such.
Okay. Another one is it compulsory for an LLC to maintain the audited financials, and for how many years? And if an entity was dormant and had no major financial transactions, Is it required to get the audited financials? How important would it be in the context to corporate tax?
So as I mentioned, the UAE Companies Law has always had a requirement for all LLCs to prepare accounts, to maintain sufficient accounting records and books of account, and then at the end of their financial year, to subject its accounts to an audit through an external auditor. That requirement has been there even in the 1984 regime, and there was no carve out or exception for SMEs or dormant companies or similar situations. So the blanket requirement, unfortunately, is that all LLCs must maintain accounting records and then subject their books of account to an audit at the end of the financial year and lay that audited account at an AGM in front of one or more of their of the shareholders or shareholder, as the case may be. Now, as I mentioned, this is important and has always been important from a compliance perspective. But the reason it's becoming more important now is because we have corporate taxation due to be or is being rolled out in the UAE as for financial years starting after June 2023. Now, what this means is that companies in the UAE need to make sure that their accounting systems and their books of account this year, being the financial year before their first tax year, are correctly audited and in a good state, so that they can ensure that when they need to file corporate tax returns, their accounts aren't a mess, which need to then be corrected after the fact. So that's why in the shadow of corporate taxation coming in, this issue has become of heightened importance, but it has always been an importance compliance issue. This requirement is not new.
Okay, thank you. One more question, actually a couple more, but what happens if the term of the board of managers or of an LLC expires and a new board is not appointed?
So I don't know this offhand, but I believe the requirement in law is to ensure that the board is reappointed within a prescribed period of time. And failing that, I would imagine that a general meeting needs to be convened to make sure that a board is reappointed. I don't think that the position is that the board, the term of which has expired, can continue indefinitely after it's reached the end of the term of its appointment. So I think the logical approach would be to convene a general meeting, which would then need to reappoint or replace the board. But yes, perhaps I can come back to the individual who's asked this question offline.
Yeah, can I just add that the requirement is that a company must at all times have a manager, so it cannot function without one. And if it ceases to have one, then I think the onus is on the shareholders to make sure that that is remedied.
Okay, all right, thank you both. One last question. Are there any restrictions on adjournment of shareholder meetings?
So Samira, the position in the new law is that when a shareholder meeting is convened for the first time, the quorum requirement is if a higher requirement, I believe it is 50%, at least 50% of shareholders must be in attendance, unless a higher threshold is specified in the memorandum of association. So in the first time that a general meeting is convened, you need to have either the standard specified or at least 50%. Then, assuming you do not have quorum in the first attempt, your general meeting has to be adjourned and reconvened within a certain amount of time. I believe it's between 5 and 15 days. And whoever attends that meeting constitutes quorum under the law. So that issue shouldn't, I imagine, arise anymore.
Okay. Okay. There was a related, sort of unrelated question. I'm not sure that the answer, you'll have it readily in your notes, but do you know the date for corporate tax registration on Emara tax?
So I don't know this offhand,
Yeah.
but I believe that the Federal Tax Authority has issued invitations to certain companies, to large taxpayers, to start registration. I imagine that once this first phase of invitation-only registrations is complete, they will roll out some sort of mechanism for beginning registration for others.
Okay. It looks like we have gone through the discussion points and the questions, and I'm just going to, if in the next few seconds, if no more questions are coming in, we can end the webinar. And I thank you all for joining us, and thank you, Bashir and Samad. And as I mentioned earlier, okay, there's one question that just came through. We can, can an LLC be owned by one shareholder at 100%?
Sorry, we were on mute. Yes, an LLC can be owned by one shareholder 100%. However, as just discussed earlier, there is a special naming convention that applies to single shareholder companies, and that's an issue that one needs to bear in mind if one is proposing to have a single shareholder limited liability company. But yes, in theory, yes, you can have it.
Yes, the name must identify the fact that it is a single shareholder company as part of the name of that LLC, which is a bit cumbersome.
Okay. All right. Can you include different classes of shares under a local LLC?
No, you cannot. An LLC must have a single class of shares, all ranking the same way. So again, taking a step back, perhaps the limited liability company, the term company is actually a bit misleading. When you talk about LLCs, one should look at them as closer to that of a in form to a partnership than to a company, as is traditionally understood in, for example, common law regimes. And so a company, an LLC, more correctly has interests rather than shares, even though the term shares is frequently used. But to answer the question, all shares of an LLC must be of the same class and rank the same.
Yeah, it might be better to look at shares in an LLC, the word share being perhaps closer to a portion rather than a share certificate. So it's much more similar to, I guess, a partnership. Having said that, I would add that recently this year, there is a new federal family business law, which seems to override the company's law on a number of subjects. And one of them is the provision to allow for shares voting and non-voting.
We just received another question to elaborate on an answer that you gave to the previous question on a sole shareholder. Shall the company still conduct an annual meeting and appoint an auditor in a case of a one shareholder?
So look, I appreciate it seems a bit perhaps excessive, and it doesn't need to be. In the case of a single shareholder company, one imagines that it doesn't need to be as formal an affair as it would be where there is more than one shareholder. But yes, the requirement to appoint an auditor, as I said, exists in law without exception. It must be done. The manager, which may not be the same as a sole shareholder, must then call a general meeting, which again would consist of just one shareholder, and then go through the process of getting the accounts approved by the sole shareholder. Now, admittedly, in a single shareholder situation, this would not really be, one imagines, a formal meeting that would be convened, but yes, the process needs to be followed. There's no exception to that.
Okay, thank you very much. I think we will just end here. And as I mentioned earlier, this session is recorded, and we will share the recording and the slides with you. Any questions that have come in that have not been addressed during the webinar will be addressed offline. And feel free to approach any of us. All of you have my email address. I sent the Zoom link and the confirmations. And feel free to approach Bashir or Samad directly if you have any further questions. And thank you again, and see you at our next webinar. Thank you.